Rob Butler.
Thank you very much indeed, Mr. Deputy Speaker, and I welcome this bill, and most especially the way in which it further incorporates the Armed Forces Covenant into law. I'm very proud to have two RAF bases in my constituency, RAF Halton, which is primarily a training base, and RAF High Wycombe, which is home of Air Command and will soon be home of Space Command. I pay tribute to all the service personnel at Halton and Wycombe, and indeed serving everywhere in the UK and worldwide. It is absolutely right that they and their families be treated fairly and with respect wherever they're asked to live and work. Mr. Deputy Speaker, I'd like to focus my remarks today on changes to the service justice system. They stem from my own experience in the civilian criminal justice system prior to my election, specifically 12 years as a magistrate and a time on the Sentencing Council. My particular interest then, perhaps unsurprisingly, centres on concurrence between the two systems. I take the view that if an offence is committed by a member of the armed forces in the UK, and that offence is not directly linked to military conduct or the maintenance of good order and discipline, the defendant, witnesses, and victims should be afforded the same broad principles and rights of justice as if the offence had been committed by a civilian. So I'm pleased to see that there are several clauses in this bill that aim to achieve exactly that as a result of the implementation of recommendations from the review by His Honour Judge Lyons. Notably, these include allowing more junior ranks to sit on a court-martial board and permitting only one dissenting voice in majority decisions of court-martial boards, rather than the current system that requires just a simple majority. I'm also very pleased to see the introduction of a power to rectify mistakes, which reflects the system in the civilian criminal justice system. One area that does give me cause for concern, however, is the rejection of Judge Lyons' very first recommendation, that unless the Attorney General decides otherwise, the offences of murder, manslaughter and rape should be investigated and prosecuted in the civilian system, not investigated by the service police and prosecuted at court-martial. These, after all, represent the most serious offences, and it's imperative that they be handled in a way that will ensure confidence from all participants in the justice process, most especially victims, as well as the general public. Now, these offences weren't subject to the service justice system prior to 2006, and consequently, following the Lyons recommendation would not be undermining a very long-standing precedent. And indeed, Judge Lyons' report states that in many other countries, such as Australia, New Zealand and Canada, offences of this serious a nature are dealt with in the civilian system unless an exemption is granted by the DPP in the case of Australia or the Attorney General in the case of New Zealand. Now, the intention in this bill is instead to require the Director of Service Prosecutions and the Director of Public Prosecutions to agree a protocol to determine whether civilian or service jurisdiction apply in cases of murder, manslaughter and rape. And I'd therefore be very grateful if the Minister could expand on the principles that will guide this protocol. Because, Mr. Deputy Speaker, I am absolutely sure that, like me, the Minister wishes justice to be done and be seen to be done when serious offences are committed on those rare occasions by service personnel in the UK. And I feel confident that the added information that I seek will provide crucial reassurance that will further strengthen this excellent bill. Thank you, Mr. Deputy Speaker.